Hello. Earlier this week, in the case of Hildebrandt and Williams, the District Court of Queensland determined the construction of a will, and they had earlier in another case of Frey and Frey done the same thing. I thought it was important to just bring to your attention that the District Court has jurisdiction in these matters, provided of course that the subject matter of the application, which will be the value of the item that's in dispute, or the construction of which is vague or ambiguous or what have you, is not greater than the jurisdictional limit of the court, which is $750,000. So it's just an option there, and it has been realised on a number of occasions. Interestingly, there have been at least 5 construction cases this year, looking at both courts of Supreme and District, and the matters that were the subject of those constructions will be incorporated into the text in due course. But I thought that you'd be interested to note that in other jurisdictions, construction applications are becoming a little more common, perhaps as a result of more homemade wills appearing, but it's certainly an important area of practice because of the growing number of problems with the construction of wills. 2 other things I just thought I'd mention when it came to construction of wills is that we've had a couple of local comments on the principles to be applied following Fell and Fell, the summary of Justice Badice in Ashton and Ashton, and also the remarks of Justice Atkinson in the Public Trustee and Smith are certainly worth noting. In one of those earlier cases I mentioned in the District Court, the key to the construction was the provisions of section 33E of the Succession Act, which says that when you come to construing a will, the will is dealt with, or considered as if it was made just before death, so it speaks from the date of death, and that was the key to, as I say, the case. Actually it was of Frey and Frey that I mentioned earlier. Hope those comments are of interest, and